Gore's motion for limited discovery is about to be heard, and of course the defendants filed oppositions to that. Manson's lawyers are taking the opportunity here to get in what hopefully will be the last word before the judge hears this and makes a decision. Manson's attorneys filed 4 documents yesterday to rebut what the defendant said about the limited discovery request. We'll go over those quickly. There's another declaration by Howard King, his attorney. There's a reply to Wood's opposition to the limited discovery, and then Manson also opposes Gore's request for judicial notice of the Gore versus Gore documents and also Gore's objection to his evidence. Let's start with Howard King's declaration because it's an admirable 1 page. Okay, that's like a miracle for a lawyer to put what he wants to say on just 1 page. It's not even single spaced. It has 2 pieces of information in it that I think are interesting. And the first relates to Ashley Smithline. If you remember, or maybe you've seen on Twitter, I've shared part of a joint stipulation in the Bianco versus Manson case that the parties agreed that discovery was going along well. They needed a little bit more time, but that they both agreed that they were collaborating in good faith with each other and had noticed depositions of non-parties. And now we see at least who one of those depositions will be, and that's Ashley Smithline. King notices in his declaration here that in the Bianco case, she has been subpoenaed to testify for that case on August 17th. King's next piece of information relates back to the original hearing on setting this motion for limited discovery up for an actual hearing rather than just dates. King expects that if the motion is granted, they're going to have to adjust out the dates of the anti-SLAPP motions. In other words, even if he just gets this limited discovery or perhaps even slightly more limited discovery, due to the timing of the parties and Ashley Smithline's deposition, which had to be noticed in conjunction with her counsel's schedule, those things will not allow for the hearings to be heard quite in time, just not enough time there. So expect at this motion for limited discovery, if he is successful, he's obviously going to ask the hearings to be pushed out a little bit, which is perhaps reasonable. Let's take a look at Manson's objection to Gore's request for judicial notice of the Gore versus Gore documents. And Manson's attorneys cite cases that say, if you take judicial notice of other court papers, such as an affidavit, you cannot take judicial notice that the facts alleged therein are true. Well, that makes sense. Just because somebody provided an affidavit in another case doesn't mean those things were true. Now, that's different than taking a specific court order that has specific findings of fact in it and saying, well, I'm seeing these things as true. That's different. Manson's attorneys here saying that the affidavits that were put forward in that case, you can know that they were put forward there. That was sworn testimony. But you can't say that those things are automatically true. And that, I think, is a solid argument. Now, he also makes the point that these affidavits, to the degree that they go after Bright and Gore's credibility, are mere weighing functions. And that's not what you're supposed to do at this stage of the case for the anti-SLAPP motion. And I agree with that as well. It might matter later for Bright and Gore's personal credibility, depending on what she has to say in more detail later. It's not determinative here because the credibility of the witness is something that you would look at later. Manson only has to show his prima facie case. In Manson's opposition to Gore's objection to his evidence, he's basically making the case that if things are double hearsay, such as what Agent Langer said, such as what Ashley Smithline said, those things would be cured in the limited discovery. That he's going to be taking the deposition of Ashley Smithline and he intends to subpoena this agent. So he's not saying, let me get all the way to the motion and rely on double or triple hearsay. What I'm telling you is these things exist, and if you give me the discovery, I'm going to have that information directly for you to consider That's a pretty good argument. He also argues that the other matters are completely relevant to the case, whether they're proven or not. Manson makes a very good point. We're not saying these are proven facts at this point, but we're saying they're in contention and the evidence is here. We're not here to weigh credibility or talk about this person might have a motive or this person didn't exactly say this was correct. We're here to show the prima facie case. And I think that's pretty persuasive for looking at most of these things. While some things could be excluded as double hearsay, if you get the discovery, you're either going to have to put up or shut up. And if you don't, then the judge, if he's not inclined to give discovery anyway, is probably not going to look at double hearsay stuff, and it becomes a tougher case for Manson because he does feel like he needs this discovery to get past the anti-SLAPP motion, I think, or else he wouldn't be trying so hard to get it. So it's important that he gets this discovery to get past these motions. But in any respect, I think he has the better side of the situation right now that for purposes of what we're doing here, Judge, look at these affidavits. This gets us to the main document, which is Manson's reply to Wood's response to Manson's request for limited discovery. And there are 2 themes in it. One, We're only asking for a narrow range of discovery, and these people are going to have to set for discovery later anyway, so there really can't be any prejudice in them having to do it now. And then the second theme is, wherever it is possible, dunk on the FBI letter. So on the first point, the limited range of discovery, Manson starts out citing some cases saying that the anti-SLAPP motion is obviously there to prevent harassing lawsuits over protected speech activity. That's true. But there is a provision for limited discovery in certain circumstances, and that the statute was not meant, the anti-SLAPP statute, to get rid of meritorious cases. It's to get rid of harassing cases. So he makes the point that his discovery request in this motion is very limited. And I wondered what he would say about this, because while he did kind of lay out the facts that he expected from each witness, etc., what would be the terms of a proposed order? And here he essentially concedes it and says, these are not unbounded depositions, as Wood states. We are willing to have a bounded range of topics. And that, I think, makes his case for limited discovery stronger, because in theory, this would not be a fishing expedition. This would be an order at this stage of the case to set for a deposition on topics that are just referenced in whatever order is to come. You can ask about this letter. You can ask about this meeting. You can ask about the communication with these people within this time frame, kind of thing. You can't ask about what she's doing right now, or just the general things that you could in a deposition, which typically are essentially unbounded. Manson's attorney is saying that these would be bounded, narrowly tailored depositions for the things that are at issue in this motion. And he makes a good case that they're going to have to set for discovery later. And in this, he counters an argument that I think people have seen coming, and I've seen coming, and probably is going to come, which is that if this case were to get narrowed down by the anti-SLAPP, Wood is basically saying, I didn't do this stuff, okay? I didn't make the defamatory statement about the groupie video. You got Gore allegedly saying that. I didn't hack into the computers. According to your own complaint, she did it. All you're basically doing is trying to tag me in this lawsuit saying, well, I wanted to go along with it. And so let me out of this, because there's, especially if the anti-SLAPP is successful on the conspiracy for intentional infliction of emotional distress, does it really matter if there was a conspiracy on these other things, which are very defined acts? And Manson's attorneys addressed that, saying that, no, we've alleged enough here that you were involved in a conspiracy with Gore, and that makes you vicariously liable for her actions and vice versa, depending on the circumstances. And that we've also alleged that she was your agent, and I guess this is why they try to make a big point of her being an employee of Phoenix Act and that sort of thing. Although, from the finances we've seen on Phoenix Act, how could anybody have been employed by it? But that's not proven at this point. All we have are the allegations that she was. So Manson is saying inside the complaint, we're showing that you were principal agent and also co-conspirators for all the things that we're talking about. So he's already moving to make sure that everybody knows where he's going to stand on that argument. But some of the specific things in a reply that stand out, and it's not that lengthy, are these. On the FBI letter, Manson's attorneys try to rebut the idea that Wood's attorneys have that this letter was subject to judicial privilege, even if it is false, because it was only filed in a court proceeding. And so true or false, it can't be a subject of this separate lawsuit, that's a litigation privilege. And there's, they have a good legal argument for that. But what Manson's attorneys come back and say is, no, we alleged in the complaint that this letter was produced outside of the litigation context and would be used outside the litigation context. It was found by Brighton Gore at a later time on Ilma Gore's iPad, and that there was testimony that they were sending it back and forth. And Manson notes in his own complaint that he's alleged that this letter was going to be part of this conspiracy. But remember, we talked about in the complaint that he said, upon information and belief, note in this motion that he says the letter would be used for this conspiracy against him. This is still some loose language here. This is a little bit loose to me, kind of like Wood's declaration about, I believe the document was true when I filed it. I didn't knowingly make any statements. I mean, watch verb tenses and what these lawyers are putting in these things and what they're not. So upon information and belief, and then it would be used. Is there really a fact coming in the near future that says this letter was shown by one of the defendants or their agent to this person, and here's the evidence of that? Not an interview somebody did on YouTube or something somebody posted on Instagram, which could be true, but it has to get into evidence, right? So if you want to link this document to this conspiracy, at some point you can't talk about, well, I think it would be used for that. You're going to have to show that it was. So again, that could still come. I'm not saying that it isn't going to come, but if it had already come, you would be seeing it right here. Instead, they're referring back to the allegations of the complaint. Moving beyond that little bit of loose language, they come back to the dunking function and talk about Wood's declaration about how, hey, when I filed this letter with the court, I didn't knowingly make a misstatement. I believed it to be true. And they say, whatever that actually means, this letter was a fraud. It was a forgery, and they did know it. And there's no excuse for it. And they don't even dispute it. So they're just a series of massive dunks, just complete dunks on the phrasing of her declaration and what that means in terms of the fraudulent use and creation of this letter. And they make the point repeatedly that neither Wood nor Gore address where this letter came from, who wrote it, what the intent was behind it, or do anything to dispel the notion that this was part of this chain of acts to make Manson look like a serial abuser who was super dangerous. Again, maybe he is a serial abuser, super dangerous. That's kind of beside the point for this stage of the case, which is he's saying this letter was part of that. And for sure, their only winning argument here potentially is, Judge, even if all that's true, don't look at it because it was filed in this child custody case and there's no evidence of it showing up anywhere else relevant to this case, which I think is a powerful argument. But it leaves out there Manson's core contention is, Judge, these people have massively lied to the court about things that pertain to this case, about a child custody case, and they want you to ignore it because of litigation privilege, even though we're in a different case talking about it differently here. They need a technicality to try to avoid forgery, fraud, and impersonating a federal officer. That's also a powerful argument. Even if it doesn't all turn out to be true at this stage, it's a powerful argument. I would rather be in Manson's shoes on this argument than the defendant's shoes because they're trying to keep this thing completely excluded. It definitely looks bad, and they do not. And that's perhaps because they cannot address the source of this letter. And by cannot, I mean, obviously they could not know, but it also can be they cannot do it because it would just confirm what Manson is saying, how it was created and what its purpose was. This one's very messy for the defendants, and it's no surprise that the attorneys for Manson would just dunk every opportunity they get on it. And the final theme that runs through this is Manson's attorneys saying, well, what's Wood's problem if we ask Gore about this letter then? Why would she be caring about having it struck out here? And kind of using this division in the defenses to say, well, why would this person care what we do with this person and this person care what we do with this person? Hey, Gore hasn't even filed a declaration in this case. She's not disputing anything. Wood's the only one talking on this thing. And that has also created online, I think, a view in some people that maybe these defendants are not completely aligned on this case. And I wonder that too, although I can also see a strategy where they are aligned and you just let Wood do the talking for now. There are a couple of reasons why that could also be true. But that's still, right now, I think a net benefit for Manson. It lets the defendants be a little more technical in the arguments on trying to get things excluded or dismissing these causes of action. But then it surrenders the narrative to Manson because now he gets to say whatever he wants to say, bring up whatever evidence he wants to bring up. And he pounds, throughout these documents earlier in here that we're alleging these people were co-conspirators. They are liable for each other's actions because they were in a concerted course of conduct to damage Manson. So if Gore made a libelous statement, a slanderous statement, that's also going to be imputed over to Wood because it was in furtherance of their common scheme, and vice versa. So he's setting up these arguments that you can't just pretend like, hey, I didn't know anything about this, because the allegations of the complaint completely tie you into it. So there's nothing radically changed in these documents that are filed. Everybody wants to have the last word. The one real piece of information in it I thought was new was that they have noticed the deposition of Ashley Smithline. The rest of it are arguments that are more refined than they have been because they're all laying cards on the table and trying to beat each other's hand. But it still comes down to this judge is just going to make a decision. Do I want to allow a little bit of discovery and push this out a little bit, or now I'm going to decide it on what I've got in front of me? That's a lot just how a judge feels about these kind of cases, and on that I have no insight. It is apparent from the transcript of the hearing on having a hearing that the judge really wasn't going to get involved in anything other than how in the hell did this end up in my courtroom without a date on it, and let's get this date set. And if I do grant this motion, I have no idea whether we will or not, we will have to look at the dates of the anti-SLAPP motion. This was only a couple of minutes that these attorneys communicated with each other. So the real showdown is coming, and we'll know very soon who gets the better side of this. Both sides have put forth some really good arguments, I think, and therefore it kind of comes down to how the judge feels about this case, and that's something I don't know. But we will all know it soon. Thanks, bye.